Hi, everyone. Harry here to talk about the Supreme Court's big oral argument this morning in U.S. versus Rahimi. This is a Second Amendment case, and it's likely to be when there are, surveys of the court's term come June, one of the 3-4 big cases cited. All right. Let me tell you, let me just start with the guy involved who the Fifth Circuit said has a constitutional right. I shouldn't be laughing, to possess guns. He is an incredible piece of work and nasty character. And one way you can think about this case is it's amazing. It's even up for grabs that a guy like this can be prevented from possessing a gun. All right, Zackey Rahimi. He's right now in jail for all kinds of offenses. He deals drugs, does all kinds of things with guns, etc. He is quite the piece of work. So he pulls a gun on his ex-girlfriend in a parking lot. They're having an argument. A witness sees them arguing. He shoots at the witness. At that point, a protective order is issued against him. And one of the things it holds is, sorry, pal, you may not possess firearms. You had this and shot at a witness in a parking lot. You don't get a right to possess firearms. That should be sort of straightforward, by the way. But I'm not done with Rahimi. He ignored the order and continued to possess firearms. He threatens another woman with a gun in the middle of the night. He's got a drug customer he's mad at, so he fires an AR-15 into his house. And then, in a sense, the coup de grace, he goes to a Whataburger with a buddy. The buddy's credit card is declined, so he takes out his gun and shoots it in the air. This guy is a obvious, dangerous, antisocial guy who shouldn't be permitted to be within 10 miles of a gun. Nevertheless, there's a court out there, a court arguably more extreme than the current Supreme Court, that held he has a right to it, and that's what set up this case. That's the setup. Now let me go to this court and the big precedent that's at issue here. So it's the Bruin case in New York that the court decided a couple years ago. That was like the second big statement from the court on the Second Amendment, the first being the Heller case that reinvigorated the Second Amendment. And then in the Bruin case, New York had a long-standing conceal and carry law. And you could get a permit to keep a gun concealed, but you had to make certain showings that you weren't dangerous and that you knew firearms, etc. You just had to make a showing. The court, per Justice Thomas in the Bruin case, struck down that law. And said the Second Amendment right, there's a Second Amendment right to possess and carry, which that, by the way, to bear arms. And New York is therefore violating the Constitution when it's asking people to make a showing that they're safe and they should be able to have a permit. Very controversial and far-reaching decision, and the methodology of it in particular, because Justice Thomas, writing for the court, said the way we're going to evaluate the Second Amendment is by looking at whether there's a history and tradition in the country. This isn't even at the constitutional founding, but all the way through, of regulating just like this. And they find at least that there wasn't a particular history and tradition of regulating conceal and carry laws in this way. Therefore, they strike down the New York law. So that is the big precedent at issue here. All right. Bring us now to today. First, I want to note a little Supreme Court tip. The caption here, U.S. versus Rahimi, not Rahimi versus U.S. What that means is the United States appealed from the Fifth Circuit ruling as opposed to the other way. The Supreme Court, always vital to remember, decides what cases to take. And that it took this case suggests that, this opinion is just too far to permit the Second Amendment to shield a dirtbag like Rahimi. And they're probably going to reverse. But if and when they do, don't be fooled. I mean, if they don't, holy cow, what a crazy extreme court. But I've made clear my view of the court as being very extreme and on a general sort of sledgehammer project to remake the law. And don't be fooled when in May or whatever the headlines come, oh, look at this. See, the Supreme Court does a progressive ruling in finding an actual limit to the Second Amendment, because, it really doesn't say very much to say that the Second Amendment can't be used to shield a guy like Rahimi from getting guns. All right. The opinion under review, here's what happened in it. They took the Bruin case, did the Fifth Circuit. So after the court below said, here's your, I'm upholding this protective order. You can't possess a gun. Bruin comes down, and the crazy ass Fifth Circuit says, under Bruin, we don't see a history and tradition of regulating people based on domestic violence, abuse. So we're dutifully following the Supreme Court, and we're going to say there's a Second Amendment right. Just to hear that shows the sort of flaw with the history and tradition case, at least if it's applied narrowly. It's kind of mind-boggling. Of course, there's not a history and tradition. This country was incredibly derelict about domestic abusers until, 20 years ago, 30 years ago, or whatever. And it says very little to say there wasn't a tradition of regulating them before. But that's what the Fifth Circuit's saying. Remember, Rahimi, for all his he's been convicted of a crime since, but as this comes up to the court, he's a domestic abuser, but not a convict. It's clear if he were a convict, he would be able to be prevented. Okay, so that's the Fifth Circuit's application of the Bruin case. We don't see a history and tradition. And that's the really important point and the setup for today's oral argument. Not who's going to win or lose. I do think that even this court will say Rahimi doesn't have a right to a gun, but it's the so-called history and tradition case that Thomas wrote in the Bruin case. A couple justices were flatly critical of it. Justice Jackson, Justice Kagan, Thomas, and Alito, the most extreme, Tweedledum and Tweedledee of the court, obviously were supportive. But there was an interesting long exchange between the Chief Justice of the United States, John Roberts, and the Solicitor General, that is the highest official in the United States to argue before the Supreme Court, Elizabeth Prey-Logar, who said to the court, look, this history and tradition case has been really giving lower courts fits and has been achieving unjust results, because what courts have been doing is looking for really precise replications of the individual regulation over the course of history and tradition. Like here, we don't see specific regulation of domestic violence abusers. And if they don't find it, saying there's a Second Amendment right. That's just not the way it should work. They take what they hope is a modulated position that the court will adopt. They're not saying overrule Bruin and there wouldn't be 5 votes to do it, but they're saying, yes, okay, history and tradition, but don't do it in such a narrow way. Why should Rahimi be able to be kept from having a gun under a history and tradition case? Because he's one of a group of people, and there are other examples, who are basically outside the class of, and this is the word that the U.S. uses, responsible persons for whatever different reasons. And there is a history and tradition of saying folks like that shouldn't be permitted to have a gun, the Second Amendment notwithstanding. A guy like Rahimi, with his terrible record of abuse and domestic abuse, fits comfortably within that category, and that should be the basis for the decision here. And so that it's a pitch pretty much to the center of the court as the center again of this extreme far right court, that being Roberts and Kavanaugh, saying you should without overruling Bruin really adjust it so that lower courts aren't doing this really sort of persnickety precise. This is always the problem, by the way, with history and tradition cases. How exactly are you defining the history at issue? So in abortion, for example, is it a history of permitting abortion, or is it a history of permitting reproductive rights? In same-sex marriages, is it a history of permitting homosexual marriages, or is it a history of permitting, intimate relationships? And the argument by the United States here is some of the lower courts and the Fifth Circuit here just get too tight and narrow gauged in their application of the history and tradition case, and the court should make clear that the history and tradition case has more play in the joints and can comfortably fit a dirtbag, I'll stay with that legal term, like Rahimi, for being precluded from carrying a gun. Okay, now, as I say, I think they're going to reverse here, and don't be fooled if and when they do. But there'll still be possibly some real internal debate in the court about the nature of the Bruin test. And so probably this is a case that when there's, a dissent or concurrence and all said and done, it might be toward the end of the term, say May, by the time we hear what the court does. When it does, don't focus just on the bottom line, but really focus on where the court has left the jurisprudence of the Second Amendment, and in particular this Bruin test promulgated by Justice Thomas, saying it has to be based on history and tradition. See if the court doesn't make clear that there can be and has to be more room in the joints than at least the lower courts have interpreted Bruin since it was decided a couple years ago. All right, so there you have it. The incredible facts, the craziness of thinking about a guy like him having a constitutional right to possess a gun, but most importantly, how exactly the doctrine will be adjusted or not to permit states to have more leeway in keeping responsible or irresponsible persons or, general dirtbags from possessing guns. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.